David Berkey, it's probably unrealistic to assume that everyone's behavior in a co-op or condo will be great. If it gets bad, though, what can a board do to rectify the situation?
Carol, not everyone behaves properly all the time, all right? The problem that our boards are faced with are when individuals go overboard and they misbehave on a regular basis, causing all kinds of havoc within the building, disturbing their neighbors, violating what you and I would consider the tenets of good behavior.
Right.
So a cooperative is fairly simple in terms of how a board deals with those issues. There are provisions in proprietary leases that deal with objectionable conduct.
So they have a path.
Exactly. A condominium is a much more difficult structure because there is no eviction possibility. A board cannot oust a unit owner from his unit. So
let me just ask, is that eviction possibility what drives the behavior change in a co-op?
Absolutely.
So you don't have that tool in a condo?
Correct. If you are standing at risk of losing your apartment because a co-op board is going to evict you for objectionable conduct, not only is it a type of behavior you cannot cure after the decision has been made to throw you out, but now you must find a new home. Okay? That is a huge club that co-op boards have. Unfortunately, condo boards do not have the same club. So what they have to do is they have to either go to court and sue the unit owner or the unit owner's tenant if the unit owner is not the occupant but it's the tenant causing trouble, and get an injunction to stop that improper behavior. And that's a very expensive process. So boards have tried to figure out an alternative strategy so that they can obtain a lever that causes some kind of economic problem to the unit owner that would make the unit owner pay attention and moderate the behavior or stop the bad behavior.
And what is that?
Okay. The boards have the power, assuming their bylaws provide the power, to create rules and regulations that govern individuals' conduct and the conduct of lessees or occupants of units. And the boards also have the power to levy fines. And if a board pays attention to that club and imposes a system of graduated fines so that the first violation, which is essentially a warning, has a reasonable fine, but a subsequent violation has a much more onerous fine designed to deter that conduct, generally a unit owner will stop the misconduct. And if it's a unit owner that has a tenant, the unit owner is going to be the individual against whom that fine is imposed, so the unit owner will also stop the tenant from engaging in that improper conduct.
And just let me ask, as you step up the ladder in fines, how onerous would you imagine the fines would get before it would, so it could catch somebody's attention?
Well, we have buildings where the boards have imposed an initial fine of $500 for a violation, a fine of $1,000 for a second violation. And what we recommend is if those fines don't work, that the board be empowered to adopt a fine that the board, in its discretion, believes will be sufficient to compel appropriate behavior.
And what would your advice be to, I assume, condo boards in general regarding this?
Well, the first step the condo board must engage in is to review its documents. It has to see if it has the power to adopt the rules and regulations governing behavior and the power to fine. Not every set of bylaws has that power. So if that power is missing, then the board needs to amend the bylaws. And that requires usually a supermajority unit owner vote to accomplish that amendment. I honestly can't believe that unit owners would not vote to give the board the power to regulate misconduct in a building. They would certainly want to live in a building that is comfortable, and usually if a board asked for the power, the board should get it. So assuming the bylaws have that power, then I would do two other things. Okay, I would adopt rules and regulations designed to deter the improper conduct, and it goes from late night parties to excessive noise to conduct that is abusive to staff within buildings or abusive to neighbors. All of these kinds of behavior should be restricted by the condominium's rules and regulations so that people first have notice, okay, because they're obliged to follow the bylaws and follow the rules and regulations. The New York Condominium Act at 339J requires unit owners to strictly comply with the bylaws and the rules and regulations. So there's a legal basis for this board to adopt those rules and for the unit owners to have to follow them. The next step would be to make sure everybody knows about them. Okay, once the board adopts the rules and regulations, they must notify all of the unit owners of these new rules and regulations that have been adopted. And they have to be careful. If we get to the extreme side of the dollar amounts of fines, there is case law which essentially says the fines cannot be confiscatory, but they have to be designed to achieve the behavior goal that the board wants to obtain. And what the courts do is they use the business judgment rule when dealing with condominium boards so that the court will first see if the board is empowered to adopt the rule and the fine. That means it will look at the bylaws to see whether or not that power is granted to the board. Then it will look and see whether the rules and regulations are designed to further the legitimate interest of the condominium. And then with respect to the individual case, they'll see whether the application of the fine in the individual case is done in good faith. You're not singling someone out for abusive retribution when you wouldn't do the same for others. So if the board checks the bylaws, adopts the rules and regulations, doesn't act in a draconian manner imposing a confiscatory fine, the rules and regulations are likely to be upheld, and hopefully the goal of nice, calm behavior within the condominium will be achieved.
Very good. Thank you so much.
You're welcome.